Alrighty, hey, it looks like we are live. Just checking in to see if everyone can hear me. Sorry for the little delay here, but it's been an exciting day. I'm George. I'm one of the founders of Solo Suit. I'm going to go over some of the basics on how to respond to your debt collection lawsuit today. Alright, and I'm just going to go ahead and jump into things. It looks like everyone can hear and see me okay, so that's good. If not, just put a message in the chat. Okay, looks like we're good. Alright, so thanks for coming to the Solo Suit webinar. We do these webinars about once a week on Wednesdays. Good to see everybody. I'm just gonna do a brief overview on Solo Suit and how we can help you out, and then we'll get into your questions. It's largely a Q&A, so you can put your questions into the chat right now. Hannah will get to those on text. Also, I'll be responding verbally over here. Alrighty, Scrappy, good to see ya. So, yep, good to see you guys. Okay, Christopher, hello. All right. Okay, so we are Solo Suit. We help you respond to debt lawsuits. Usually, how things go is you get a complaint and summons in the mail, or someone hands it to you personally, like they knock on your door and they're like, "Got a pizza for you, surprise! It's a lawsuit," right? And they get you like that. Or sometimes they run across your backyard and like throw the papers at your kids. Just depends on the situation. Hear lots of crazy stories out there. So that when you get the complaint and summons, the next thing you need to do is you need to file an answer document. Okay, this is a capital A answer document. It's not just like a piece of, not just like a letter you handwrite on a piece of paper and then send it to the lawyer. It's not a phone call to the lawyer. It's a formal legal document called an answer document. Usually there's between 14 and 30 days to respond. So there's usually a deadline. You have to respond, depending on the state, within 30 days. If you don't respond, then you automatically lose your case by what's called default judgment. Right? It's a default judgment because that's like the normal judgment just means you lose because you don't respond. Alrighty? So you can use Solo Suit to respond to the lawsuit. You can use our answer document. Okay, if you just go to solosuit.com and you click reply to the lawsuit, you can generate a response in about 15 minutes. You can pay us to have an attorney review it. We'll file it for you. We'll calculate the filing fees and the filing information for your court. We'll get the document filed for you. Then once you do an answer, what oftentimes people do is immediately after, they will send an offer to settle the lawsuit. If you agree that you owe the debt in some portion, usually settlement's the nicest way to wrap this up. It's even better than a dismissal oftentimes. If you don't owe the debt at all, if you don't know what this debt is, they're suing the wrong person, probably not what you want to do is settle. Probably don't want to settle. So you can continue with the lawsuit. Maybe you could use like a motion to compel arbitration or something like that and try to get the case dismissed. All right, so for settlement, we have a tool called Solo Settle as opposed to Solo Suit, and you can send an offer to settle on there. And currently, we're doing a thing called Solo Settle Premium, where you can arrange to have a partner of ours, partnering law firm, settle the debt for you, and also even represent you in the case, which is a big win. So you'll just fill out the Solo Settle part on the website, and then once you get to the end, there's a link that you can click to upgrade to Solo Settle Premium and take care of that on the website. Alright, so Those are some of the basics. Happy to jump into questions now. If you guys want to put your questions into the chat, we have lots of people on here, so hurry quick. Type away or type like this on your phone, however you guys are watching. Put those questions into the chat, and we'll get to them. Before I do, I just want to offer our disclaimer. You gotta have a solid disclaimer that's required by law, which is that I'm not an attorney, I'm not your attorney. Solicit's not a law firm. We don't represent you in this case or any of your lawsuits. This webinar doesn't replace the advice of an attorney. You should consider hiring an attorney to fully represent you. Oftentimes it's not much of an option for people. Those are just some things I say because of the regulations around the legal space. Alrighty? Okay, so looks like we got some questions coming in. Melissa, it's okay that you were late. I was late as well. Okay, we got Jose. Hey guys, can I sue a debt collector once and for all, either prove that I owe them or stop reporting on a time-barred account? I guess the big question for me is whether or not the collector has sued you already. If the collector has sued you already, then you can file what's called a counterclaim, which is kind of like a new lawsuit. You'll be like countersuing them for like bad practices or something like that. If they haven't sued you, then yeah, you can always sue. The reality of the U.S. court system is that you can sue anybody you want at any time, for any reason or for no reason, really, right? You can file a lawsuit, and then if it's a useless lawsuit, if it's a dumb lawsuit, then you'll lose the lawsuit, but you can file a lawsuit against anybody anytime. So if you want to sue the collector, go ahead. I'm not sure if you'd get an attorney to represent you in the case, but you certainly could do it. I think what you're looking for is, it sounds like you're being hounded by a collector for a debt that you dispute, that maybe you don't owe it or you disagree on how much it is or something like that, and they've never actually proved that you owed it, and they also haven't sued you for it. What you want to do in that case is a debt validation letter. A debt validation letter cites the FDCPA, Section G, I believe. I think it might be like 1692G, and it requires the collector to prove that you owe the debt, to provide validation that you owe the debt. If they can't do that, then they have to leave you alone. If they can do it, then they can continue trying to collect or even sue you for the debt. So probably you want to do is a debt validation letter, right? And that happens kind of before the complaint and summons, right? So before the complaint and summons, you might have received a collection letter, and then you want to respond with the DVL, or the debt validation letter. And sometimes if they respond to that, it might go on to like a complaint and summons or a lawsuit or something like that. Or they might just leave you alone, and they might just drop the issue. All right. So that's the general idea there. We do have a debt validation letter available on our site. You can go over there and generate it. You have to mail it out on your own, but you can generate the document with us. All right. On to the next one. Chris, hi, I use SoloSuit to answer the court on being sued and need to know what to do next. I have a court date. All right, Chris. Yeah, a lot of people come onto this webinar with that same question. Probably what I point most people to is Solo Settle Premium. If you're interested in settling, that's a good choice. If you don't want to settle, then you could do something else, like maybe file our motion to compel arbitration. That can also be an option if you want to settle. But I think right now, I'm thinking about it currently, is that that's a better option if you want to try to get the case dismissed. So you can file a motion to compel arbitration, trying to increase the cost of the case, hoping the person will drop it because they don't want to pay for arbitration to collect. But if you want to settle and you have a hearing, you go to solosuit.com/solosettle. So you just check out the, I could even show you real quick. I'll just pull up the website, and it's pretty straightforward, but I think visual is oftentimes best. Okay, so here we go. So this is our home page here. What you want to do, if you want to settle, you just go click Settle a Debt Lawsuit. That takes you here, and your debt with Solo Settle. Click the Get Started button, and then you might have to log in, or you'll make if you already have an account, you'll click Already Have an Account, and you'll just go through, you answer a few questions, and then you can upgrade to Premium at the end. Alright, so that's the general idea, and even with our partnering law firm, they'll show up at the hearing for you, so you don't have to. In most cases, not all, but most cases, you won't even have to show up at the hearing, which is pretty sweet, right? And they'll actively work to get that case settled for you. So that's a big win. All right. If you do that today, right? I mean, even if the hearing is just a few days away, they'll probably be able to show up to that for you. A couple other thoughts on that. Once you file, or once you upgrade to premium, the law firm will reach out to you. You'll engage with the law firm. You'll have to sign a few onboarding documents. So just watch your email for when those documents come through, and make sure you are on top of those. Okay. Sean, what if you were not served? All right, Sean, unfortunately, yeah, that's a real thing, right? So you're supposed to be served right here when you get the complaint and summons. Unfortunately, sometimes people experience sewer service. What that means is, the first time you find out about the lawsuit is after you've lost it, or you find out after it's ongoing, but you just were never actually served the documents, right? And both of those options can be bad news. They might have served the guy down the street. They might have just put the documents in the sewer, right? Thrown them right down the little drain on the street, and said, "Oh yeah, I totally served that guy." All kinds of things that they could do, but it's a common thing that happens, unfortunately. If you found out about the lawsuit and you still have time to answer, then you'll want to contact your court, or you can use, Anna can put in our solo suit case status blog post into the chat. You can find out what the status is of your lawsuit, maybe online, and maybe download the complaint and summons, so then you can respond to them by filing an answer through solo suit. If the time the answer is already passed, you can do a motion to set aside judgment. You can email us. We have a template for that. Those are some options before you. Alrighty, Stephanie. What if you did not answer and you have a court date? Can I still use solo settle? Can you still use solo settle? So kind of how that works right now, it's a little bit can get a little bit complicated at the moment, because it's things are a work in progress. If you did the solo settle premium, then we could actually work that out for you. You'd want to do that ASAP, absolutely immediately. And we can, if you signed up, if you do solo settle, and then you upgrade the premium, we can work on that answer with you once you get that done, and we'll kind of, we can talk to you and get that taken care of. So if you want to start with solo settle premium, you can do that. Ordinarily, we recommend people go and do the answer first and then the solo settle. But in this case, feel free just to go over to solo settle, upgrade the premium, and get it done. All right. You definitely don't want to delay because, I mean, ultimately you need to have an answer to settle. You don't need to have an answer, but you're going to get better leverage and a better settlement if you have an answer. Without filing an answer, good chance they won't even talk to you about settlement. All right. Christopher, tenant won a civil suit for deposit refund. What happens if I do not pay this judgment? Tenant won a civil suit for a refund of the security deposit. What happens if I do not pay this judgment? Oh, hey, that's a new one, Christopher. I haven't heard that before. So it sounds like you're a landlord. I feel like that's great. Good to you. Way to own land. So that's good. You're wondering if you don't give the deposit back to your tenant, huh? You know, usually we talk to people who are trying to get their deposit from the landlord, but you know, happy to help out the landlords as well. Basically, what happens? So if the tenant already won, and you don't want to pay the judgment, so kind of what happens? So the tenant, let's say the tenant has the judgment, they won, case is over. How people have to collect on a judgment? Ultimately, it's difficult to collect on a judgment. Okay? Collectors are probably the most proficient at it, but the reality is that billions of dollars, it's an estimate, billions of dollars go uncollected from lawsuits every year. That's because the courts aren't really that preoccupied with judgment, with actually collecting the money. They're actually just occupied in like giving the judgment, and they kind of consider their part to be kind of done once they've made a ruling. Anyways, what happens is, so the judgment is given, and then the winner has to collect on that. Usually how they'll do it is by garnishing someone's, they'll try to get the person just to pay them straight up, like, or agree to a payment plan of some sort. If they can't do that, then they'll garnish the person's wages. So they'll have to file a writ of garnishment in the court, and then they'll file a document with the person's employer, and then the employer will send a check for up to 25% of the wages, monthly wages, to the person with the judgment, to the person who won. If they can't garnish the wages, then they'll try to get a lien against property. Being a landlord, you obviously own property, so, and the person, I suspect, knows their whole address, so they'll probably know the location of the property, and they'll be able to get a lien on that property, so that if you sell it in the future, then a portion of that will go to pay off this debt, plus interest that's accrued at that time first. So the sale will first go to pay off this debt. So that's some ways that they'll try to collect. Of course, that takes quite a bit of effort on their part. A security deposit is probably worth less than like $3,000. So, you know, there's some chance that they might not follow through with that. So you can certainly just kind of wait and see. Judgments are usually good for quite a long time, like 10 to 20 years in most states, and they're infinitely renewable usually. So even after the 10 years is expired, person can usually renew them. Yeah, so those are some thoughts, but I mean, if you feel like you're in the right here, regardless of what the judge has said, and you don't want to pay the judgment, then, you know, that's certainly something that you can do. Again, I'm not giving legal advice, I'm not an attorney, I'm not like telling you either way, but yeah, a lot of people don't pay judgments out there. Alright, let's take a look at the next one. Looks like I missed Scrappy here at the beginning. I got a letter from an attorney on June 10th stating that I owe a debt for a car loan. I did buy a car in 2009, and after becoming unemployed, I returned the car and hasn't heard anything since until now. I did buy a car in 2009. And then he became unemployed. He returned the car. Hasn't heard anything since until now. Okay. So you got a car with financing, and you're unemployed. You returned the car? Scrappy, I'm not familiar with the process of returning a car. I feel like I've heard of people doing that only ending badly, like once or twice. I'm not aware of this like option to return a vehicle. Um, but generally speaking, yeah, I mean, if you like, there's three people involved. If you bought a car with financing, right? You bought the car. Uh, and so there's there's the dealer, and then there's the bank, right? So if you bought the car with financing, the bank actually owns most of that car, right? If you had like a $20,000 car, you paid $1,000 down. The bank owns, and bank paid other 19,000. The bank owns $19,000 of that car. So then if you just take that car and you like drop it off at the dealer and say, hey, I don't want this car anymore, and then you don't tell the bank, then the bank doesn't know, and they're expecting to own a $19,000 of a car, and if you just stop making payments without telling the bank, then that could be a problem. I'm not sure if that's like what you did here, but you'll certainly want to work things out with the bank in this case. And I'm not exactly sure how that would work. I mean, you'd get the dealer to pay the bank, possibly. Either way, if you're being sued for debt, in most cases, almost all cases, you're going to want to file an answer to respond to protect yourself from default judgment. Then you can try to win your case, or you can try to settle after doing that. Alrighty, moving along. I'm going to have to end at about 5:30 Mountain Time today, because it's candidly, it's my baby's 9-month birthday today. I got a baby who's 9 months old, so it's her in and out day, right? She's been out for 9 months, and she was in for 9 months, so we're celebrating that in a little bit. So I've got to go sign off here pretty soon. I'm going to try to get through these questions a little bit more quickly here. Okay. Let's see, got lots of questions coming in. All right, Liz, if I send the answer myself, should I include a copy of the original complaint with the answer? Yes. William Greenback, I filed an answer and a motion to arbitration with a pretrial next week. What can I expect to happen at this pretrial? Pretrial conference is usually where it's you, the plaintiff, and the judge, and you guys are going to talk about scheduling for the actual trial. So the judge is going to ask you, have you guys tried to negotiate a settlement? Do you want to continue with this if you are unable to negotiate a settlement? If you both say yes, then I'll set a date for a trial. That's usually what happens. Just come prepared, bring documentation, look nice. Decide whether or not you want to settle or not. Liz Wentworth. I intend to use Solo Settle to settle, hopefully, but I want to send the answer. Yeah, great. So click the reply to a lawsuit button on the site, and then go over to the Solo Settle your debt. You can just do it all in the same day, and take about an hour maybe to get it both done. Legal/work. If the collector is suing you, don't they have to prove you owe them, not the original debtor? Yes, that's totally right. That's how a lot of these lawsuits are won. Right, so our latest research shows that about 25% of the time, at least, our customers' cases just get dismissed. And that's usually because the collector can't prove that you owe them the debt. Yep, so there you go. Jules B. Hi, I followed the first step, replied to the courts, and no court date has been set. Yeah, great. So you want to make sure that you send the answer to the court as well as to the lawyer. And then sometimes cases get dismissed for lack of prosecution, meaning the plaintiff just drops the case and things never go forward, right? Lack of prosecutions, that's one reason why things get dismissed. totally possible that things could pass on for like a year or more, and a court date never gets set. Definitely, should I file an answer before court on June 30th? It depends on the state. Some states you really don't have to file an answer. There's only a few, like select few states you don't have to file an answer before showing up. I don't remember any of those states off the top of my head. Maybe Virginia's like that. But usually you want to file an answer, and most courts will even allow you to file an answer even if they don't require it. And that will put you in the best position to win the case. And sometimes people will get confused. Sometimes the summons will say, you must appear in court by this date. And what they mean by appear is actually like file an appearance. And what they mean by that is like file an answer. So oftentimes it sounds like they're just telling you to show up in court in person, but actually they're just asking you to file a written answer. All right. Christopher, how can I get this paid if I want to pay the judgment? The magistrate won't facilitate payment. Oh, interesting. So, Christopher, it sounds like maybe you lost the lawsuit, and you want to pay it off. How do you do that if the magistrate won't facilitate payment? I mean, if you showed up at court, you'll probably just talk to the lawyer and like arrange a payment with them. Or you can give a phone call to the collector and try to set up payment, or you can go to the collector's website. Oftentimes you can set up payments online. Or you can even try to make an offer through solo settle. People settle after a garnishment, after a judgment is granted even. Especially if you can do a lump sum payment. If you got a judgment against you for like $3,000, you can do a lump sum payment for $2,500. They might take that all up front instead of trying to garnish your wages over time. Margaret, initial hearing is in September, but he sent requests for a lot of paperwork I don't have access to do due to moving. I closed my practice and filed bankruptcy for my biz only, but they said I signed. Okay, so it sounds like you had a business and you were a personal guarantor and you had a business debt, and they're not coming after you personally for that debt. Usually if you personally guaranteed a business loan, just gonna write that down here. So we're talking about a personal guarantee. Usually if you personally guaranteed a business loan, yeah, they can come after you pretty clearly in your personal assets, which is unfortunate. If you already filed an answer and you have a hearing scheduled and you want to get help with this, and you did personally guarantee the debt, then again, solo settle premium is going to be a good option. You just go over solicitor.com/solo settle, fill it out, upgrade the premium. You can get a law firm to represent you and get that taken care of for you. Especially if it's business debt, there's probably quite a bit on the line, so even a better option for you. Just to clarify, usually businesses can't use solo settle premium, but a consumer can, and it sounds like you're being sued as a consumer for the previous business debt. Margaret, a guarantee of one of the signatures on the contract is not my signature. Okay, so maybe a business partner signed it. Again, if like both of you signed it, they can come after one of you or both of you or all of you. Yep. Jules B, what form to file to get it dropped? I think Hannah might answer that as well. If you want to, generally want to file an answer, then maybe motion to compel arbitration. If it's a credit card debt lawsuit, then there's an arbitration clause. Liz Wentworth, I think I got skipped. If I send the answer myself, sorry to skip you, Liz. If I send the answer myself, should I include a copy of the original complaint with the answer? In most states, you don't need to do that. Maybe in some courts, you do have to include the complaint summons. Usually, almost always, you don't. For solo suit, we just include the answer, certificate of service, and we send that for you. Christopher, that would be an evicted tenant, sent text and email, no response, last known address not verified, so I'm not comfortable mailing a check. Oh, interesting. Yeah, that checks out. That makes sense. You don't want to send the check if it's just going to get lost in the mail. If you really feel like you want to pay the judgment, you just don't know where the person is, then usually you can file like a request for information into the court, and then the court can require a party to provide information. Usually it's the other way around, where they're trying to get the debtor to pay, like to give the information, but you could probably do this to get the holder of the judgment's information. Yalassi, I sent out a response to my debt lawsuit with Solo Suit using the standard package, and I haven't heard back a response for a month now. Is that normal for them to take that long to respond? Yeah, we usually don't expect people to get a response for at least a month, or around a month. Liz, I have the answer drafted and ready to go. I'm wondering if I need to include a copy of the paperwork that's issued to me. Yeah, generally speaking, no. Margaret, I tried, but they want a bigger retainer than the 26K. I tried talking to their attorney, but he's being a jerk. Okay, I'm not sure what we're talking about here with the retainer exactly. Yeah, sometimes attorneys can be jerks, especially if you aren't paying them. Yeah, if you want to settle, again, solo settle premium could be a good option for you. Can I still use solo suit premium to take over this case? Yeah, solo settle premium. It's a little confusing right now in the semantics. It's different from our answer. We have like a premium answer package you can buy. What you're looking for is the solo settle premium. Okay. Liz, the service is amazing. Thank you, Liz. I'll be back to help me settle. Just needed a little advice because I want to make sure I don't lose the case automatically. Yep, that's great. Don't want to lose automatically. Yamassi, thank you. Jules, thank you. Excellent. Jules, what if I don't have a court date set after filing from the other lawyer back in February 2023? Yeah, again, depending on the jurisdiction, that can be pretty normal. Chris, my court date is July 11th. Is there still time to settle? Yeah, there's totally still time to settle. You can try calling them yourself, like calling them over the phone, emailing them, sending them a letter. You can do solo settle premium. That's certainly a fine timeline, especially if you sign up like today. Louis, since I filed a motion to compel, the collection agency has gone silent. How much time do I have to respond? It's a good question. I don't have much visibility or knowledge actually on like the deadline on that across the states. It varies from jurisdiction. A lot of courts have like a general deadline of around 30 days to respond to stuff, to respond to motions generally. But I've certainly heard of collectors taking longer than that and then filing a motion like years later sometimes on stuff. Like if they take too long, right? Ultimately, you want to check out the rules of civil procedure for your state. It's the rules of civil procedure. Rules of civil procedure. RCP. For your state, and that will have a deadline in there. And then you could, if you really want to be proactive about it, you can file like a motion to dismiss for lack of prosecution. We don't help with that document, but it is a document you could try filing. Just saying, like, they haven't done anything, so let's get this case out of court. Joseus, I have a lawsuit that I responded with solo suit, but I've not received a response from the attorney. It will be 1 year in August since I responded to the lawsuit. Wow. What can I do to remove the debt? Yeah, so there you go. Good example. Been a year. That's so long. You can try filing motion to dismiss for lack of prosecution. We don't help with that document again, but you can try filing it. So Louis, I have 30 days to respond or lose my case, but the collection agency has forever to respond. Yeah, it seems pretty dumb, doesn't it? I think most rules of civil procedure are going to limit the number of days they have to respond, but it seems like for whatever reason that doesn't get enforced. Hannah, maybe that's like an article we can write on, by the way, Hannah, if you want to make a note of that. Because this topic comes up quite a bit, and I actually don't know the deadlines. Operating in 50 states is pretty unusual. That's what we do. I don't know the deadlines across all the states. Happy birthday to your baby. Happy 9-month birthday to your baby. Thank you, Joseus. Thank you. Congratulations. That's great. Okay. I'm being taken to court for credit card debt I did submit an answer, but not they are motioning for them to win the case, but last payment in 2017. How would I proceed? Yeah, you definitely want to. You filed an answer. If they're filing a motion for summary judgment, you want to file a counter motion. You can try to settle. So premium. You can get a law firm to take care of all those motions and weird stuff and hearings for you, and also settle for you. So that's a good option. Maybe the statute of limitations has expired. If it has, you definitely want to fight that and bring it up in court and try to get, total victory. Answered questions, TH, I answered questions on a form in NYC that is now regarded as my first answer. Okay, great. Yeah, some people, NYC I've heard makes it like New York City. I've heard it makes it kind of easy to file an answer. You can like go in person and orally respond. They'll draft an answer for you. I've heard that's the case if you can, get to the courthouse through all the traffic, etc. Legal work. What do you do about a request for admission and production of documents? So that means you're in discovery. So that's like another stage. It's another stage of the lawsuit where they're trying to get evidence and get you to say stuff. Again, you can try to settle. You can get a law firm to represent you. You got to respond to the request for admissions or interrogatories. Responding to a request for admissions is kind of like responding to the complainant summons. Oftentimes, you just kind of say no to everything. John, I had you submit my general denial answer. I would like to follow up the answer with a motion to dismiss for specific reasons. How long should I wait before I ask the court to dismiss? Really, no time at all. You can file a motion to dismiss right after the answer. We don't help with that. I think we might have a template if you email us. We don't have like a product online for it. But yeah, certainly could be a good move. Receive notice of intent to file a lawsuit. What do I do? You can send them a debt validation letter, or you can just get ready to file an answer. Know that you got a solo suit in your back pocket. We can help you win. Statute of limitations is 3 years from last payment. Can you all help with the next step? Basically, on that situation where you're going to want to do like solo settle. Well, if the statute of limitations did expire, no, we don't really have like a route specifically for that. You just want to keep on filing documents until you get a hearing, and then bring it up in the hearing, prove that it was expired, and then win your case. And you can be one of the happy 25 to 30% of people who get their case dismissed. All right. Well, good to see everybody. We're gonna call that a wrap for today. Again, we are always rooting for you guys here at Solo Suit. We want each and every one of you to get the victory in your lawsuit that you are hoping for. Let us know what we can do to help. Good to see you. Take care.